Hello friends, today I'm going to discuss a GST new judgment of the High Court. This is the paycheck and copy of invoices not ample to prove the genuineness of the transaction. Supreme Court denies the ITC claim. The state of Karnataka versus Messrs. Income Gill Coffee Training Private Limited, citation 2023. Tax scan. The input tax credit claim was rejected by the tribunal in the Karnataka High Court and finally the Supreme Court of India, which was presided by the Judge Amar Shah. The bench observed that the mere production of invoices or even payment to the seller by the check cannot be said to be the sufficient and may not be said to be discharging the burden to claim input tax credit to discharge under the Section 70 of the KVAT. And the order issued by the High Court and the ITT proving the ITC was declared unsustainable by the Supreme Court. In such case, it is the quest and set aside. The sit is quest and set aside. Bench of Supreme Court to decide the constitutionality of GST levy on rent lease payment. Chief Commissioner of Central Goods and Service Tax versus Messr Safari Rates Private Limited versus and Ors citation 2023 tax matter. Two judges bench of the Supreme Court on Tuesday granted leave to a special leave petition challenging the judgment delivering by the Odisha High Court on issue of levy of GST on the rental or lease payments. Disposing of the petition, the High Court had held that if the SC is required to pay GST on the rental income arising out of the investment on which he has paid GST, it is required to have the input tax credit on the GST which is required to pay under Section 1755D of the Central Goods and Service Tax Act. No liability to auto pre-deposit for bill in GST cases. Absence of completed assessment. Supreme Court Judge Rajesh Kumar Dudani versus State of Uttarakhand and ANR citation 2023 tax scheme. The Supreme Court had recently held that appellant has no liability to pre-deposit half of the revenue loss in the absence of completed assessment to crystallize the tax liability to be released on bail. The bench of the Supreme Court Justice Krishna Kumar Murari and Ahsanuddin Ahamulda was also observed that the same view has been reaffirmed by this court in another similar case, Criminal Appeal number 523/2023, Anath Bhai Ashok Bhai Saab versus State of Gujarat and Ors. It was thus remarked that fact of the present case being identical to the fact of the aforesaid two criminal appeals, we see no reason to deviate from view taken in the aforesaid two cases and held that following the reasons given in the said judgment and the orders, we are the considered opinion that appellate is entitled to granted anticipatory bill without imposing any condition as suggested by the learned additional Solicitor General. Supreme Court uphold the pre-deposit import condition to claim IGST and GST compensations under advance authorization scheme. Union of India versus Ors the Cosmo Films Limited. The Supreme Court of India upheld the requirement of the pre-import condition incorporated in foreign tax policy and handbook of procedure 2015-2020 by notification 33 2015-20 and notification note 79 2015 customs to claim exemption of integrated goods and service tax IGST and GST compensations on the inputs imported into India for manufacture of export goods. On the basis of advance authorization, the court commented that the introduction of the pre-import condition may have resulted in hardship to the exporters since they could no longer continue with their former business practices of importing the inputs and after applying for advance authorization to fulfill their overseas export contractual obligation. Inquiry pending for 5 years due to non-appearance for summon under Section 70 of the GST Act. Supreme Court granted opportunity to appeal before the concerned authorities, the state of Gujarat etc. versus Chudamani Parmeshwara near and ANR 86 citation 2023 taxes. A division bench comprising Justice J.B. Pardiwala and Justice Prashant Kumar Mishra of Supreme Court ruled granted one more opportunity to the respondent SC to appear before the concerned authorities for interrogation. The bench observed that though the inquiry was pending for 5 years due to non-appearance for summons issued under Section 17 of the Central Goods and Service Act 17, Supreme Court was inclined to grant such relief. The High Court in its common order had stated that the petitioner shall appear on before 11 Jan 2019 before the concerned police station. However, the Supreme Court disposed of the case in favor of the respondent on the condition that he shall appear before the authorities. Otherwise, the authorities may continue with the issue in accordance with law. Thank you. We will discuss rest of the thing in the next video or coming video. And if you are new into my channel, please subscribe to my channel and like, comment, and more and more you should share this video so that it can reach to the suitable person to whom it is required. And if you are not required, please read and try to understand what I have said in this video. Thank you.